There's so much to know about estate planning. So much indeed that the most common concern that I hear from potential clients like you is that they've heard all this information. Oh, my friend said do this. Oh, I read this online. This worked for me. And they just don't know what to do next. And instead, they freeze. Hi, I'm estate planning attorney Jay Sherrill. Today, I'm going to tell you about the four most common myths of estate planning. Number one, I'm too young to have an estate plan. This is a common concern that we hear from clients. I've had a 90-year-old client tell me that he was too young to do his estate plan. He actually came in 2 years later and got it done at 92. Listen, the estate plan is how we plan for the unexpected. If something happens to you suddenly at any age, you need to have picked who your healthcare agents are going to be, who your power of attorney is going to be, and who your beneficiaries are going to be. Because if you don't make those decisions, the state is going to make those decisions for you, and you may not like them. Number two, my estate is just not big enough. Hey, I'm not a Rockefeller. Right? I'm not a Roosevelt. I don't need an estate plan. These are for the rich and the famous. And that's simply not true. Everybody has an estate, whether you know it or not. Everybody has a plan, whether you know it or not, because the state is going to make those decisions for you. But through your estate plan, you get to protect yourself from lengthy guardianship proceedings and also choose to leave the legacy that you desire for your family. Number three, estate planning is all about money, or I just don't have enough money to do an estate plan. This is a dangerous myth because one of the most important parts of the estate plan is to protect against a crisis. Like, what happens if you had a car accident today on the way home and you were no longer able to take care of your finances or take care of your healthcare decisions? If you're married, you might think that your spouse would be able to do these things for you, and it's simply not true. Actually, if you haven't taken the steps to have a healthcare proxy in place, a power of attorney in place, a living will in place, a court could actually decide those issues for you and appoint a third-party guardian to take away those rights from you and make those decisions for you. Number four, having a will help my estate avoid probate. Now, this is one that we see all of the time from clients. Now, I'm not exactly sure where they got this from Google, from their friend. All of our clients want to leave a clean estate for their beneficiaries. And they think they can do that by avoiding probate. And I would agree with them. But the misconception is that by preparing a will, that your estate will be clean and avoid probate. And that's simply not the case. By definition, every single will needs to go through probate. That's the process where your executor will have to prove the validity of your will before a court allows anybody access to your estate. This could tie up your money for months on end. That's why people seek to avoid probate. And the myth is that the will avoids probate, but no, the will forces probate. The way that people avoid probate is by using trusts. Look, estate planning is not just for the rich and famous, and this area is overloaded with misinformation and things my friends did and my neighbors did. This is like going on WebMD and finding out that your cough, it really means that you're dying tomorrow. Or going to your dermatologist and asking them to perform open heart surgery. Look, what you need is a dedicated estate planning and elder law attorney's office like Sherrill Law PC to give you tailored advice to your desired legacy that you want to leave for your family. That's why we offer all of our new clients a strategy session to look at their desires, their assets, their family information, and customize an estate plan that accomplishes their dreams. Call us today to schedule your consultation.